I am not ashamed to admit, well, actually, I'm just ever so slightly ashamed to admit how much I am enjoying this whole Stormy Daniels Trump fiasco. It is just beyond entertaining. But we are not here for entertainment. Instead, we must entertain a legal question, which I think is a very interesting one. Does Trump have presidential or executive immunity with regards to these claims by Stormy Daniels? Unsurprisingly, Trump does claim that he has executive or presidential immunity, but Trump says a lot of things. So we have to look to the law, and there are a few specific cases that we can look to figure out whether, in fact, there is a basis for Trump's claim. In Nixon versus Fitzgerald, a 1982 Supreme Court case, the court very specifically stated the policy behind presidential immunity. The president's absolute immunity is a functionally mandated incident of his unique office, rooted in the constitutional tradition of separation of powers and supported by the nation's history. Because of the singular importance of the president's duty, diversion of his energies by concern with private lawsuits would raise unique risks to the effective functioning of government. While the separation of powers doctrine does not bar every exercise of jurisdiction over the president, a court, before exercising jurisdiction, must balance the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. The exercise of jurisdiction is not warranted in the case of merely private suits for damages based on a president's official act. What they're saying is the immunity is grounded in the separation of powers, for one thing, but it's also grounded in the importance and unique nature of the president's job. And thinking about a lawsuit against the president, the court would need to balance the value of having that lawsuit against the intrusion on the president's duties. Now, if you could imagine how popular, how known, how busy a president is, it would be crazy. Anyone could sue the president. So at the very least, and you can get this from the last line right there, the Supreme Court has determined that as far as civil lawsuits stemming from the president's official duties while in office, at the very least, there's already been a determination that that's simply not worth it, given the unique job that the president needs to do. We need to look towards the next relevant Supreme Court case to determine whether actions taken before someone was president can be subject to the presidential immunity. Unfortunately for Trump, based on the next case, it looks like those types of actions are not covered by executive immunity. The case that I'm referring to is Clinton v. Jones, which is a 1997 U.S. Supreme Court case. Now, this case had to do with allegations of sexual misconduct, which allegedly took place prior to the president being the president. President Clinton, of course, attempted to avail himself of presidential immunity in defense of these claims, and the court held that immunity from civil damages arising out of events that occurred before the president took office cannot be sustained on the basis of precedent. In this case, there was an additional question, which would be interesting also for the Trump case. They asked, even if the immunity does not apply, is there anything in the nature of the immunity that would require the court or that would allow the court to defer the action at the very least until after the presidency, right? So if you think about it in this way, if part of the reasoning behind presidential immunity is that the president is so important, so unique, has so many things to do that he can't be bothered with a civil lawsuit, can we retain that action but defer that action until after the presidency, after the term? And the court in this case held that deferral of the litigation until the end of the presidency is not constitutionally required. Now, this particular question had a lot to do with the separation of powers doctrine, which is interesting because that's part of where presidential immunity comes from, but it's not the only place where presidential immunity comes from, as we discussed before. It's notable here that the court did not consider whether a comparable claim would succeed in a state court. What they noted here is that if this case were being held in a state forum, instead of advancing a separation of powers argument, petitioner would presumably rely on federalism and comity concerns, as well as interest in protecting federal officials from possible local prejudice that underlies the authority to remove certain cases brought against federal officers from a state to a federal court. As you can see, it's an entirely different policy reasoning when you're looking at a state court versus a federal court. In a state court, there's more of a concern over federalism, which is a balance between the state governments versus the federal government, as opposed to the concern about separation of powers, which is a balance between the executive branch, the judicial branch, and the legislative branch. Now, if the claim were brought in a state court, I think that's a really interesting question that's not entirely clear. Although the Supreme Court has left this question open, we can at least explore the factors which would go in favor of an argument for immunity in a state court and the factors which would go against that argument. As far as arguments in favor, I believe that the best argument would be a federalism argument or an argument over the state court's jurisdiction in terms of someone suing a federal executive in state court who also has a federal defense. I think that could be a potential issue. But on the other hand, in favor of the argument that there is no immunity would be the factors that this activity took place completely outside of the scope of the president's duties in two ways. First, it's outside of the time scope, but it's also outside of the scope in terms of the nature of the activities. If you think about it, sexual activities are not really a function of executive office. But would someone consider the fact that there's an argument that this is a campaign contribution as something which ends up tying this to the federal office? I think that's an interesting question. It might be a damning claim to make, but it's something to think about as a potential complicating factor. My tendency is to believe that Trump probably does not have a valid claim of either executive immunity or presidential immunity, and that's just based on my understanding of the law and of the facts as I understand them today. Now, keep in mind that as with most legal questions, it's very hard to draw a bright line because these are common law questions, and which means that they come up through the courts and they're decided specifically on the specific facts. And, one fact can really change anything in a legal case. Either way, I'd love to hear what you think, so please comment below. What do you think based on my explanation? If you like the video, please subscribe, please share with your friends, please comment and interact and let me know what you think. I'd love to hear from you, and you can tweet me also. I'll be back with more videos on relevant legal questions, as well as the interviews that you've probably seen before if you follow my channel on various issues that might be of concern to libertarians, conservatives, and actually anyone who's interested in learning more about the other side of an issue. Thanks for watching.